So the Hussein Haffajee case is the third judicial inquest that we've done since 2017, looking into an apartheid-era death in security detention. Dr. Hussein Haffajee was arrested by the security branch back in 1978. He was an underground operative for the African National Congress. He was brutally tortured and, we believe, murdered in detention. That case is currently before the High Court in Pietermaritzburg in South Africa. We still have to present our closing arguments, which we believe will happen in early 2022. So far, none of the cases referred by the South African Truth and Reconciliation Commission to the National Prosecuting Authority have come to trial, and very few indictments have been issued. These were the cases investigated by the Truth and Reconciliation Commission involving very serious crimes such as murders and massacres. And in these matters, none of the perpetrators applied for amnesty, and in cases where they did apply for amnesty, they were denied amnesty. So they were meant to face justice, and regrettably that has not happened. We believe it hasn't happened because of political interference. And regrettably, there is quite a lot of evidence of this interference. For example, the former Attorney General, or as we say, National Director of Public Prosecutions, Vusi Pikoli, provided us with a sworn affidavit in which he set out details of instructions he received to close down these cases. And ultimately, when he refused and decided to go ahead with a few cases, he was suspended from office and was ultimately forced to leave. And indeed, others who tried to take cases forward were frozen out of these matters. The cases so far will be brought under South African domestic law. Here we're referring to statutory law and the common law. We have been trying very hard to persuade the National Prosecuting Authority to amend some of these indictments to include crimes against humanity under international customary law. We have provided very detailed memoranda and opinions in an effort to persuade them to include these charges. Given the nature of apartheid and the extensive program of repression and abuse of civilians, not to mention the fact that apartheid itself is a crime against humanity, we believe it's absolutely appropriate that in South Africa, of all places, apartheid-era perpetrators ought to face appropriate charges, including prohibited conduct under crimes against humanity, and of course, the crime of apartheid itself. Until yesterday, we had been unsuccessful in persuading the authorities to take this step. We have been trying actually since 2005 to get the authorities to take action. But I'm pleased to advise that only yesterday, we're talking the 22nd of November 2021, the Director of Public Prosecutions in Johannesburg Andrew Chaki, agreed to indict 2 perpetrators accused of the murder of the COSAS 4, with murder as a crime against humanity as well as apartheid as a crime against humanity, in the alternative to the existing domestic murder charges. This, of course, is an enormously significant development and a very welcome one, and we believe it's going to significantly advance the cause of justice for victims of apartheid-era crimes. It is correct to say that prosecutors and judges on the continent of Africa are facing considerable political pressure. Indeed, this isn't just a phenomenon in Africa, but in many countries around the world. So the question is, what can be done to resist that political pressure? In the first place, it requires courage on the part of prosecutors and judges and those involved in the administration of justice to stand firm and to resist pressure from wherever it comes, be it the executive or from other elements in society. After all, they are appointed typically under laws and under constitutions that guarantee their independence. And one would hope that they would find the courage and the strength within themselves to stand up to political interference and to do their jobs under law and the Constitution. I accept, of course, that this sometimes places them at risk. And indeed, if those risks are too big, then frankly, it's best that they don't do that job. That's not a job for them. They should be doing other work where they're not facing such risks. It's also up to civil society to protect judges and prosecutors by reminding powerful elements in society that these institutions, the judiciary, the prosecution services, are meant to be scrupulously independent and are meant to act free from interference. They should be active with advocacy. They should be active in the media, publishing op-eds and writing articles, reminding societies why it is so important that the judiciary and the prosecution service remain independent. And when necessary, where there are encroachments, they perhaps should litigate on the matter and obtain declaratives from apex courts such as constitutional courts on the question of the independence of the judiciary as well as the prosecution service. Also, steps should be taken to develop prosecution policies to guide the discretion of prosecutors in the difficult decisions they have to make on a day-to-day basis. Many countries have such prosecution policies that set out in really great detail the different criteria upon which they are expected to make decisions whether to prosecute or not. And these policies are important because where prosecutors apply the policies to the letter, that affords them some protection, because then they can't be accused of pursuing a political objective or of victimizing a particular perpetrator, because they can simply point to the prosecution policy and explain and demonstrate that they have been acting under law and they have been applying the criteria in those policies, which typically are published in open documents for everybody to see. So the future of international criminal justice in Africa is uncertain, but there is some cause for hope for the future. I mentioned earlier in this interview that there's been a very significant development in South Africa after decades of struggle, where eventually one courageous director of public prosecutions agreed to indict apartheid-era perpetrators with crimes against humanity under international customary law. This is an enormously momentous event. And also, to employ international customary law is not a straightforward endeavor, given that international customary law is not codified in domestic law, but exists globally. It really is up to local systems and local prosecutors to invoke international customary law in order to hold perpetrators accountable for the most serious crimes known to humanity. Another development emerges from the Gambia, and given the energy for justice in the Gambia, I am reasonably confident that it is going to happen in some form or another, either by way of a special hybrid court, hopefully based in the Gambia, and if not in the Gambia, then in the West African region, or perhaps through a specialized chamber within the Gambian judiciary, staffed by carefully selected judges, and equipped with a dedicated investigative and prosecutorial capacity, again recruited with individuals with demonstrated expertise and experience. So there is cause for some optimism, even though there have been quite a few setbacks on the continent.